beauty. To you there's no equal.
Second to none. Second to none. With beauty, you still
For
know.
news, views, and entertainment, stay tuned to Society for Radio Democracy. 98.1, simply the best.
Say after me, sir. I solemnly swear that the evidence I shall give, shall be the truth, the whole truth, and nothing but the truth, So help me God, so help I Jah. So help me God, so help I Jah. So help me God, so help I Jah, Rastafari.
Every time I see the wicked, baby moves.
You are brought before this court for having ganja in your possession. Guilty or not guilty? Not guilty, Your Honor. How could one man do such a thing? Ganja. It is totally impossible, Your Honor.
I can remember, yeah, when I was framed and jailed, brutalized. The grudge would find me guilty for an exhibit they could not find. And every time I see a Babylon, my blood runs cold.
Court Ose. We come to you from the Society for Radio Democracy 98.1 FM. Court Ose na 1 hour program. Court Ose na 1 hour program. We come to you every Tuesday from 5 to 6. And at Court Ose Day for bring the law to people for me to understand certain things about the law. No go away, stay with me for the next 1 hour. Me way they present the program in name and Mange Mansaye. Today inside the program we get Claude Bami Davis, when a private legal practitioner, where they can talk about tenancy agreement. Good afternoon and welcome to the program.
Good evening, Fambulem. Good evening, Mange, and good evening, 98.1. Okay,
plenty time people in the talk in the area tenancy. People in the go rent, people hey, this time a tenant, hey, this time a landlord. So what is that tenancy?
Okay, thank you very much. First of all, I want to appreciate, the fact say, when I think about educating the people around the law, right? And this is a very important topic where you bring counsel to the people and in fact now everyday language in the Sierra Leone community. Okay, so tenancy, I go define and say this now a legal agreement where they grant person the right for occupy property, an agreement or the process where they make somebody tap na person in property. So if, for example, I get Ose, and then I want person for rent me house, that relationship between me as the landlord and the person who bring come na a landlord-tenant relationship. So there is that tenancy of the person we come for occupy my property. So it is the agreement where you get between two or more people for occupy a property. I mean the landlord and the tenant for occupy. It can be for a period of time. It can be for an unspecified period. It can be for a specified period. It can be for an unspecified period. And the crucial thing is in exchange for rent, because definitely for make you say there is an established tenancy, there has to be rent. That no means say there are tenancies we rent no do, but that is crucial. But we go come to the types of the tenancy. We are going to talk about the various types of tenancies.
Yeah, because you talk about the various type. Well, before they can to the various type of tenancy, at least we want for me listener they really understand. You don't talk about the tenant. What are the landlord?
Okay. The landlord, now the person we get the property where the tenant they can occupy, or furthermore to that, the person we entitled to the reversionary interest. So for example, if me papa die, he left us, okay, naina been the landlord, naina get this house, he rent mange, but he die now. Then me as me papa in Pekin are entitled to the reversionary interest of that property the way Mange Mansari occupy. So I can be considered as the landlord for that property too. So not to just because the person we actually get the place don't die, but anybody we entitled to the reversionary interest of that property. That is, wouldn't say the reversionary interest, that is when the person we actually get the property don't die, don't go. The person when I next of kin or we entitled to the interest na that property day. That property the interest they reverse to, I'm not even called the reversionary interest. They come to that person they we close to the papa we been getting the property. So it's either the person we actually getting property or the person we entitled to the reversionary interest of that property then a landlord.
Okay, so you don't talk about the reversionary interest, but sometimes in the way you talk about tenancy, then the person will be in rent the tenancy don't die. The one with the reversionary interest, we na the picking. So the way can give notice, like then go to court, then go can contest then they say, well, not to him being put me in occupation.
Well, now make we get the law we provide for the kind tenancy, then they win a cap 49 when at the summary ejectment, you know, now tell we who that can institute an action for eviction, you know. So they say that is section 3 of cap 49. They say when a tenancy at will or on sufferance, I get for come to the various tenancies them. They say we don't done or rent free, right? And person the term don't done by legal notice for quit, and then the tenant fail for quit or refuse for quit, the same person, the landlord or person entitled, you see the act tell you say the landlord or person entitled to the immediate reversionary, the immediate reversion of such tenancy may give notice to that tenant of his intention to apply for some rejectment under this ordinance. So he said the landlord, see the act, that is cap 49. He said the landlord or the person we entitled to the immediate reversion of such property or tenancy can give notice. So it not means say, as I say earlier, say because the person will not be your actual landlord, not day or you don't die. So the person we entitled to the reversionary interest, no forgive you notice. No, the act say the person we entitled immediately to the reversion of that estate, they forgive you. So if anybody they contest that, when you go to court, the law is clear. Make I just rub more quick on the types of tenancy because let people
Yes,
know
because
understand.
I did next we want for go. Yes, because plenty time people in they talk about tenancy. What are the types of tenancy then?
Okay. We get various types of tenancies, right? We get fixed tenant, okay? We have fixed term tenancy, we get periodic tenancy, we get tenancy at will, we get tenancy at sufferance. Okay, for now. So fixed term tenancy, now that tenancy way they for a term, let's say 6 months or 1 year or 5 years or 10 years. That is what you call a fixed term tenancy. Where the person they pay rent, then the tenancy they determine whose term in rent they start and whose term they done. So that is fixed term, and the tenancy they state the period. Say now from January 1, 2026 to 31st December 2026. That's now 1 year. Now, then you get what you will call periodic tenancy. It's this na a rolling agreement where it not get fixed term, okay, no defined end date. It gets a commencement date, but it not get any defined. It might be, for example, month to month or week to week, but it they continue automatically until the landlord or the tenant provide reason for notice for end am. You understand? So it get commencement period, but it not get term for end. So it automatically they renew. That is what we call a periodic tenancy. Then we get what we call tenancy at will. This is important. This now where you get an informal arrangement, okay? Who side person the tap na person in property with the landlord in consent, but they not get any formal lease agreement or tenancy agreement where they state a timeline. So now me could call as a tenancy at will. Now me, we get me property, now me put you there for let you did it, but we have no binding agreement, we have no tenancy agreement where they say now from this period to this period for the day. A day at me discretion. I can come today and say, no, I don't want you here again. Than a tenancy at will. Then we get what we call tenancy at sufferance. Tenancy at sufferance, this is a way you get tenants. They don't occupy your property. Let's say in term for done April 30, we pass so. Then after April 30, they don't hand over the property, they don't move. Automatically, when in time don't determine, when in time don't expire, and it continue for day that property day outside in tenancy period we been specified, that person day na tenant at sufferance. You say so after a lease to expire without the landlord in explicit consent, that person day is a tenant at sufferance. So now the various tenancies in that.
Okay, so you don't talk about them various tenancy there, but now if you want forgive. Okay, man, I cover the first. Anyways, so now, where somebody not tenant, you don't go rent person place, and something then they can get within they prepare what they call tenancy agreements. What not that tenancy agreements?
Okay, tenancy agreement basically na the legal document where they state the terms and conditions upon which you and the landlord they operate for the property where you occupy. So in that tenancy agreement, the 90 states, waiting you as the tenant for do as a tenant na the property. So they go, okay, get the commencement clause, usually where they talk about the parties. Claude Bami Davis, the landlord, and Mange Mansari, the tenant, for example. Then we get the recital, say, okay, I don't agree for rent this property to you for a period of 1 year, commencing on 1st January 2026 to 31st December 2026, 1 year. And stating the rent for a rent in the sum of 5,000 millions. So that is the basis, right? And then now it gets the covenants or the obligations of the tenant. So there is no actual, we would say, fixed conditions or terms. It depends on the negotiations. It depends on waiting the landlord and the tenant could agree. Some tenancy agreements can even state almost people them for occupy the property. Some landlord can say, I don't want crowd na me house. So una can expressly state under the tenancy agreement say not more than 5 persons. All right, so you get the obligations of the tenant. Tell you say you for use this property only for residential purposes. So now basically the terms upon which the tenancy they exist, waiting the tenant for do and waiting you the landlord or landlady for do. The tenant most times we get to and call in the foot the bill, the utility bills. So if for example light bill, water rates, then things and they come, we call the utility, right? Utility. Now you the feel now you the be at the utility bills then they. But then the landlord gets the responsibility for pay the city rates that is chargeable on the property. So all them then city rates the way they come off from the Freetown City Council or wherever you are, the municipality, now the landlord they pay that day because now in getting us. But the tenants now they pay the utility bills. The tenant again now you get responsibility for paint the interior. So most tenancy agreements them can get that. Say the tenant is painting the interior whilst the landlord they paint the exterior, the outside. There is one crucial thing again where people can bring out maintenance of roof. I think I have to state this. I don't get occasions them where tenants then can where clients then can call and say, "Me roof the leak. I don't know if na me for make them or na the landlord for make them." So it is the responsibility because it is an exterior, okay, part of the property. So not the landlord in responsibility for repair the roof, but anything inside, not the tenant. So all of those things. So now based on which one I don't negotiate, but you get standard clauses where they take out. Like as I say, the payment of city rates, then the standard say now the landlord or the landlady. The payment of utility bills na the tenant. Some tenants say again can say okay for even throw away dirty, you get for the middle landlord na me they pay clean salon, but you have to be contributing 10 leon to clean salon. So I mean it gets various dynamics, but the tenancy agreement na the agreement where they define everybody in responsibility and in duty under the tenancy. And so it's very important for when we enter into that kind of relationship there with landlord, they enter into that kind of relationship there with people, a fine forget a tenancy agreement. I'll tell you why. Because when you go court, if now there is an issue of eviction will arise, say in the tenancy agreement everything is defined. The period where you occupy the property for. If you term done, you no need for go begin explain bokusef na court to the judge or the magistrate. Just by the production of your tenancy agreement, we state where all two the parties then don't sign, it makes it easier for the court for determine. So if finally we get tenancy agreement, because that is what sets the tone for we landlord and tenant relationship. Again, if somebody say no, me term not done it. Sometimes you get tenants with the challenge. Say me term not done it, but the part don't go, they don't go give me notice. Now you tenancy agreement now in the show. So it is a good discipline rule for adopt. See, even you the tenant, when you take person property, the first thing you should ask for after payment of rent and receipt, now you tenancy agreement. Because outside that tenancy agreement, we're able to determine who that don't breach. Right? So if the landlord gets certain responsibilities, for example, quiet enjoyment, the landlord, when I don't pay rent, they assure me in the tenancy agreement, say I should enjoy his premises quietly. So we call them quiet enjoyment. But if you don't get quiet enjoyment as the obligation, say they assure me, say me as tenants get for enjoy this property quietly, then every 2-3 days they can create yourself they be a nuisance to the tenant. Not so because a rent you place means say you can't be a nuisance to the tenant. No, you could. So if they come every day, they bring ala or noise, or you they come, you they can't disturb me, they harass me, so you get some landlord them way because they rent person now at them place. Every morning that person they for buy bread for them. No, that is not proper. So if you get a written tenancy agreement, then all of them things in if that landlord they now they disturb you, so you can come to court for make the court impress on them for respect specific performance on waiting states na the tenancy agreement. So all of this not just the discipline we go help for create a smooth relationship between the landlord and the tenant.
Okay, so tenant you they see tenancy agreement go state say you for come twice a year or something of that day, but if you notify the tenant. So it can depend. So what do you think about that kind?
Yes, so that is correct. I make a say now the tenancy agreement na they determine waiting for happen where you tap na person property. So it comes to the point where I make just not say not all because now you ose you rent gimme means say you get right for enter the anytime for can infringe on me privacy. No. So now I make that issue of entering upon the property, then they say you forgive at least 72 hours. Most tenancy agreements, now then they say give the tenant 72 hours notice. Say, okay, Claude Bami Davis, I want for can inspect because yes, you get right for inspect. And now I make the tenancy agreement also the standard they tell you say not more than twice a year because you get for respect my own privacy. So you know mean say because you don't rent the property, give me anytime no more way you give you or we feel say no more for go disturb this person you for enter. No, say not more than twice. That is well once every 6 months if that is the case. That is the rationale. But then give the tenant 72 hours notice. Say today is Tuesday, Friday or Saturday. I want to inspect the house make a look because yes, you as the landlord again or the landlady, you get right for inspect your house for see if anything don't go bad, if don't damage. Because sometimes people they only can they go inspect when the tenant they about for move, and at that time it is late if there is any want of repairs to be effected on the property. So now I make them can say do them twice inside the year of the tenancy period. So but give the person the tenant at least 72 hours notice. Some can say 48, but I mean reasonably 3 days notice say I want can inspect. And when he can inspect, the tenancy agreement again, the standard can say make you inform the tenant of any defect where you find at the property. Say, oh, Mr. Tenant, I see that wall here that don't crack and the interior of the property. So if I repair them. Again, if in no repair them, the tenancy agreement can say, if me as the landlord repair them, then that could be deferred in future rent. So let's say you get for pay for another year, right? Then middle repair on my own cost. I they put them pan the rent where I get for demand of you for the ensuing year where you get for pay rent. So I will say, okay, you rent na 20,000 loans, but for make that wall, I've been spent 5,000 loans. So now you have to pay 25,000 loans.
But sometimes then the landlord then go say, hey, well this make way they make so now for you privacy, now for you comfort. So then thing they can happen, and if you say okay, it don't make a place, it don't make a deduct them from the rent, they know they do. I say it do them for you comfort.
Well, I understand the question that issue the way you bring counsel, but you can't when we say comfort, not to then things that we naturally for be made available in the house, right? You know, go tell me say at the current house, enough forget. I mean, like some standard house, enough forget toilet, right? So if me come and say, okay, no, I want for fixing this toilet now, you can't say now for my own comfort. It's not a luxury. These are necessities, right? So we get more able for create the balance for no. What is luxury? and what is necessity. So if me they come, I put like if you come, you say, oh no, I want put some kind camera naya or what, then for you na your own business. It has nothing to do with my property. These are outside the necessities of a property. But then think them like toilets, right? Or proper security, doors. Then think then they not to about comfort. These are things that are incidental to the property, and so they ought to be distinguished from things we are put in the property when are comfort, not from your own comfort, or from the one we actually the property forget. Some people in the rent house is incomplete, right? If you rent them, say this person not done this house yet, but me they can't do this. Now the landlord, because the landlord again definitely been get intention for fixed toilet, for example, right? But since you want them, because I don't get in situation in the back, the desperation of the tenant can say, pa, I see this no more, give me and so, me the current time, I will put all in there. Honestly, anything where you fix into that, we get for toilet, and then necessity, as I say, necessity, it get for be considered in future. And say, no, let me do this, because not to wait for the. If not them excess, them other extraordinary things, yes, for your comfort, say, oh no, this way, the way it's land so, this dining room, I not like and so, I want put and so. Una can get the agreement. I make the tenancy agreement is crucial. So some tenants they say not to alter the premises without the written consent of the landlord. All right, such consent not to be arbitrarily withheld. Some tenancy not to alter. Some can say to alter with the consent of the landlord. So I mean, it depends on negotiations or how una don't set una terms, you know.
So we don't say again situations so say people like you say, well, enough fine for day which you landlord na the same house, in the sense that in getting your apartment or in getting your side, then whilst you self rent your side, but it is see you activities there. And we cook cassava leaf in ourselves. You know, say that me place you forgive me, or sometimes then you see so say you buy a new motor car, you buy television, you buy this you don't get money, and they can't increase my rent. Because some people they say, hey, where you landlord in a house or you landlady? Hey, no buy motor car, hey, no buy this, so it go add per rent. So what you think about that? Is it they breach the tenancy agreement?
Really, then issue then individual differences. So some tenants them, well, it is generally advisable, say, you know, for deal with you landlord or you landlady at the same house. Because, as you rightly point out, some landlord or landlady then they determine your financial status by waiting and see you they do. But some not even bothered about that. Me don't get a tenant where they, as a client, we within a property with a landlord. Landlord no. He's got a fixed rent. He let you come with the fortunes of this world. Now waiting, he wants his rent. But you get majority sometimes can get them problem and they determine what you for pay, you know. And sometimes again, relationship can don't go sour. I mean, we're all humans. Sometimes we you tap, we say, not for a advisable, not for dinner the same, not for share the same space with you landlord or you landlady. We're humans. This part they see you, what you they do, but then when in rent reach for make you pay rent, you they give excuses. So it's not just automatic. Sometimes the tenants themselves can they ambog. Because if me I they see now, I mean, as I say, we're humans. You don't lose that human side of we. If I see, but this man every day, they count money, whether na money or not now, my opinion what the form that he's competent to pay my rent when the rent is due. But then anytime when I ask him when the rent is due, he gives excuses. It gets to me. So the only way most landlord can use now the strategy now for increase the rent. Say no one tell you say move na me house. because you don't the default, he's frustrated about you defaulting to pay rent, and they say, make I increase me rent. You now go to think, say, oh, this pay increase me rent because if he'll say I get money. But yes, you they forget, say, no, when it can demand for rent, if you for don't pay you rent in February, you they wait till May before you pay. You say they forget your own obligation where you owe under the tenancy. So generally, yes, I agree. Say sometimes some landlord and landlady them can get over the board and think, say, oh, this person, because I see they drive this kind of motor car, the rent where I don't charge, not to rent where if I pay the rent small. But again, most times we self knocking the test the laws. In fact, it go interest you for no say we get a law where they talk about the rent restriction. Yes, it don't become obsolete when at the na cap 52 where they talk about rent restrictions, right? So then time that we hope say that we laws here go be reviewed and revised for meet the present day trend, because you actually they wonder how some hosts then they ask for so much money, then you go get the same host, they ask for less. Now because we know them get a uniform charge of rent, but there is a law, we then call the rent restrictions. That is cap 52. In fact, all of the laws them we get for do with rent now proper now salon start from cap 49 when are the summary ejectment where they deal with how for pool person property and all. Then we get cap 50 when are the summary ejectment for the protectorate. Then they for upline where they talk about the tribal authorities, the chief them, how then they pull you na them property if somebody not so a native. And native by the definition of cap 50 na possibly not born na the provinces. Then you get cap 51 when are the speedy ejectment. You get speedy ejectment. We're indifferent from the summary ejectment. Speedy ejectment, they go for possibly we unlawfully to occupy your property, not to tenant at all. They go lay claim to your property. You can institute an eviction process through the speedy ejectment, and then you get cap 52 when are the rent restriction we talk about. So you get 4 laws where they deal with tenancy in Sierra Leone: cap 49, cap 50, cap 51, and 52. And then I think make I go quickly on notice. I don't know if you.
No, we get for now. They will get for last. Are you the pool person come on I place?
Okay.
And the program where they listen to na Court Ose, where they come to you from the Society for Radio Democracy, 98.1 FM. Yourself can be part of the program. By way you go send text message to the number 077 981 981, 077 981 981, or you can call and ask the lawyer question in waiting with a discuss. And now they give una legal advice for say bambai na so you they ask for in advice in no good one. But you ask question with the topical they discuss, waiting in understand, what you know understand, it go explain. And when we come back to this topic, when we look at something then the way person they go rent, like when I be small, me on cool them, where people then go rent to them, then the person not pay in rent on time. Sometimes then they can just then take padlock, then go lock the place. They say na me host. If you not pay me rent, I know they open this place. So what you think about that?
Okay, so just I don't state the laws them way salon get where they deal with tenancy. All right. Cap 49, cap 50, cap 51, right? Non-sign or the you see na the downside is of it. When you want to forget tenant, you don't need the court. But where you want for pull that tenant, the opposing way unlawfully go occupy your property, you then need the court. So all the acts I talk from cap 49, cap 50, and 51, they tell you about the magistrate or a justice of peace or the Supreme Court, because you know the Supreme Court in cap and then caps here they refer to the High Court. So now then one then they get authority. So you not get landlord not get right for say because tenants no pay in rent, they go padlock. That means you have taken the laws into your own hands. Now I make the law tell you say when that tenant they no pay by cap 49, it give you the processes.
Yeah, we can't to them
Yes.
processes.
Now, so you they go to court.
No, we just say if he get right.
No,
But
you
they
not
can't-
get, you not get,
we
you
go-
not
we
get
go-
any
we go
right.
for kind into them processes,
because
then
there's
how you
a
do that.
procedure how you they evict anybody we occupy your property. Now I say, see, that's the downside of it. When you want the tenant, you don't need the law. I mean, you don't need the courts for counter. You say take this tenant, but when you want evict that person, you then need the courts.
Some tenant the way we don't see again our community. Waiting sweet between the landlord and tenant. They don't go ask for receipts. Anything we do, do I no more? May tuna fumble, they no go itemize waiting and don't spend or whatever. Do I no more the kind of relationship then who get safe? I like I do we go able to understand we safe. Then at the end of the day, or Sunday you can't pay. He say give me receipt. Now my brother, now they take receipt safe na yan. Then at the end of the day, we want pull the deposit now. The deposit, no, you not been doing me so. You not been in fact, I not been give, I not been give that kind of money. No, I been give that kind of money. I not been give. In fact, I not been spend so I spend so. Where the receipt? So what do you go talk about the receipt in tenancy?
So that's an individual discipline too. Anybody way I get an opportunity for advice around that line, I would say, request for receipts, not just discipline. But we culture a little bit. Don't make it like say where you ask for a receipt. It's like believe the landlord. And again, the desperation for property. Oh, the tenants go feel say, hey, if I can ask this landlord now for give me receipt, the landlord go say, oh, because you pay me small money, well, I'm not rent you again. You have those people anyway. But so both the landlord and the tenant, we get to understand, say, this is just financial discipline or process. Say, if you the transact business with anybody in exchange for money, you get for issue receipt. Issuing receipt is even safe for both parties. You the landlord with the issue receipt first. They show who stem that person they in tenancy they done. Because when you issue receipt, okay, I hereby receive the sum of 1,000 units from Mr. B for tenancy period commencing 1st January 2026 to 31st December 2026. That person they, if tomorrow you carry and go court, even without a tenancy agreement, let us say for that, yeah, the court they able for determine say yes there was a fixed term stated. This is not from this period to this period. So for you the landlord, you don't get an advantage. But just imagine now, somebody come a rent you place, you not give them receipts, you not get tenancy agreement. Then that person there you give a notice now say let him move. He say pa not a move because me term not done it. How do you have to show say in term been done and not pay the new rent? How? You not get any evidence for sure because you had not issued receipt to the tenant. So how the person go know now? How the court go know now? So now you word against in your word. So the discipline for at both ends. The landlord for no say it is safe for him for give receipt, and the tenant too for no say it's safe for him for making obtain receipt. The tenant in your own advantage na that. If that landlord come inside the period of your tenancy and give you notice, you get a receipt or tenancy agreement. Okay, let's talk about the receipt as we say. You be able for go na court, go show the court say, look in signature. Now issue me with this receipt. Me term for done December. Then this is May. It's here for move October. Just by the production or the tendering of that receipt in a court, case closed. So it is something that it's a discipline we all should practice or should adopt, that when they do transaction, it is so safe, it is so nice that you obtain receipts for every transaction we do in exchange for money, because that is how you able for defend you or for prosecute you cause. So it's a discipline we everybody for adopt. Not say, no, if I ask for receipt, so tell the landlord go say I not believe him. Most times that can happen. People don't ask for receipt. And then we problem can now, then put the court by Agba. How the court for determine say, no, you tell me be not done. You not paying. I mean, the court cannot.
Okay, so before we come, how you pull post in a place, or probably before, or we open the phone line to we viewers and listeners them, and sometimes there's some tenancy agreement they say, for sublets, but when they see people and they come, they sublet, they put people in the. So what do you think about that?
Good. So it comes back to me opening point where I be make say the tenancy agreement now in the set the tone for the operations of the tenant within the property and the obligations of the landlord. So if me get a tenancy agreement, as stated in that tenancy agreement, they say for sublet this property, for part with any portion of this property. Then I find out say I give you this property, but somebody else he's being rented by you. That is a fundamental breach of a clause in the tenancy agreement where without more are going to court and establish that you for common on a place because you have breached the agreement, a clause in the tenancy agreement. Okay. So now most times I say it depends on which you don't negotiate because if some tenant they say, oh well we'll not get tenancy agreement or in don't can pay you 10 loans. Then it go fair another person where they can pay them 20 loans. It make money in a you aid. But if you have a tenancy agreement, you have a written agreement, we're binding between you, the landlord, and the tenant, then it is clear that when he sublet that the property day or any part of that property day, it don't breach in obligation as a tenant and if vacate na the place.
Okay, so we also get property them we like within the camp with tenants and they take over. You see then they fix this and they fix that and they were ready for come on, then go and pull waiting them fix. So what did the law say with regards to that?
Okay, then something where we call in law the issue of fixtures, right? Yes. So if you get certain property, things them where the law they consider say they fixed to the property, right? Permanently attached to the property. Now they will call fixtures. And if you not tenant, you don't put them in the, for example, like doors. You don't say because na me put this door. So when I they go, I for pull this door. Or windows, these are fixtures. Roof, these are fixtures. You not suppose, ceilings and all of those things. Because myself, I don't see plenty cases same way people when they go and pull the ceiling and say, now let me fix this PVC, let me fix that. These are all fixtures, But fittings, like standing fan, or now we say AC in a fittings, the one and they could be removed from the property. But anything we consider as a permanent attachment to the property, for pull them. If you pull them, the landlord gets right for take you to court for make the court like pay damages or the court compel you for returning things in the way you pull from the property. So it is something again where we get for discuss properly because I don't see plenty tenancies where then an issue. Somebody say, oh, now let me fix this now. Why can't they you also not been get them? If we deem them things and they say na permanent attachment to the property, as I don't explain, like windows, doors, ceilings, you not get right for pull them. If you put AC, yes, and even when you pull AC, in fact, you get further obligation. When you can put the AC, remember say they been sealed. But when you can put the AC, you been get for boss that place there for fix your AC so you go connect the outdoor unit to the AC. When you vacate the landlording property, when you pull your AC, you get for make sure say you fix that place they back like how you be meet them. Unless if there is an agreement between sometimes the other person where they can take over the place, say no, myself give a fix AC, then una can agree with the landlord, say okay, well since the person where they can take over go fix, I go still left that place there, but you have to fix it as the property was before you take them.
Okay, so now we don't deal with all them things in the, but the critical side of RAM, now how you dey remove a tenant. So how you dey remove a tenant?
Okay, for we procedure on a salon that you first of all get the required period for give notice. Okay, so for a monthly tenant, possibly they pay every month, you just need for get 1 month notice. Okay, for person where they pay half yearly, that is 6 months, you need for get 3 months notice. Okay, then for person where they pay yearly every year, you need for give them 6 month notice. And this is another crucial bit of it. The 6 month notice therefore be 6 months to the anniversary of in tenancy, not to just any 6 months. So I mean the easiest period where I don't give example of now 1st January 2026 to 31st December 2026. That is 1 year. So if me don't pay for 1 year to a landlord from 1st January to 31st December 2026, if that landlord they want give me notice say I for move, if I be within this me period and if I amount to 6 months to the term where I they celebrate the 1st anniversary or the anniversary of my tenancy.
Okay, then they itself now they other problem kinde that they say 6 months notice. This 6 month notice, it simply means to say
any 6 months.
If you give me 6 months free.
No. So now that's how they explain so now. So if I don't pay for 1 year, January 1 to December 31, 2026, when they can give me 6 month notice, it should be in June, right? You should give me notice in June, say at the end of your tenancy on the 31st day of December 2026, I don't want you in my place again. You know they come inside September, when at 3 months left, you give me October, November, December, January, February, March into another year. No, that is bad at law. It's a notice way bad at law. Because not to 6 months left again to me tenancy. Now 3 months. So you come in September for give me notice. You say, I give you till January. That is wrong. So what is expected is you get for wait till me year done. You take me new rent. Now make I say to the anniversary of your tenancy. And then again, when they talk about, no, you know for parent. No law no say we then give you notice. You know for parent. Say, because you can't give me notice. You know they tap na nobody in house. Free. No. You for pay the rent and the landlord gets right for give you notice inside your tenancy once it amounts to the period where the law provide for making give you. So if I pay, I can pay today, January 1, for example. January 6, the landlord say, okay, I don't receive you money for 1 year. But I give you notice today, January 6, where you term done December 31, 2026, you for move. That is sufficient notice. That is, in fact, out of the 6 months. It's more than 6 months. So nobody say, Naim, you don't take me money. You be not say you give me notice. You never don't take me money. No. Nobody not tell you, say, you know for parents because they give you notice. Out of goodwill, some landlord them, and then at your own discretion, can say, okay, no, you know what, since I understand, say, so tell me you get for the thing for go rent other place, I can waive the rent, not pay me rent. Go. Now, let us say for example, January 1 don't come. The landlord don't late forgive you by the time you 6 months to the anniversary been done due. That is in June, July, if I don't give you that notice there. It fail forgive you. So, it not supposed to give you notice now. If January 2027 come, 1st of January, it can say, you know what, since I don't want you at this property again for this year, I know they take the rent. But no longer say, where you term done this 2027, you not pay me, but December 31, 2027, you for vacate me. Some landlord then can say, all that rent the way you want pay me, for go fend other side where you go. Then they na your own decision. But there is nowhere in the law where they say, if I give you notice, for that period they will give you notice, for paying. There is nowhere.
Also, people can say, by the time we don't take that, if you give notice, if you give me additional time. Say for instance, myself na lawyer, somebody when they talk to me one day. Hey, well, I don't need wanna be monthly tenant. He say, but I don't need that this person who's past 20 years. Wait, he go give me notice no more than 1 month he give me. He no add. Now I say no, he no need for I say na proper notice he give. So what about them situation and the people call people like you say because you don't say na post in place. So if you ready for give notice, if you give time when free, give free time. So what did the law say?
That's again is a misbelief or a misconstruction of waiting the notice for be. Don't forget, you na an annual tenant, and that is what the law says. Say annual tenant, that is possible they pay yearly, entitled to 6 months notice. So like you don't take 50 years, they don't forget you were paying, it's not a lease. You were paying every, even if not lease safe, I'll come to that. You were paying every year. So you don't pay 1 year, yes, the landlord renew you, second year, third year, 30, 40 years. But you rent, the mode of you rent now annually, you pay every year. So the only notice you require under law now 6 months. Nothing. There is nowhere where they say because I don't tap na the place for 30 years, so you need for give me more time. So meaning like if I give you 5 year notice, no. Now 6 month notice. Even in leases, they tell you say if you don't lease this period for a fixed term, 20 years. It say if you want to renew your lease, you for notify the landlord or the lessor 6 months or 3 months, as the case may be, to determination or a determination of your current lease period. And not say because I don't lease them for 20 years, so the landlord for carrying for give me notice for all that 5 years before I move. No way.
Or he give you free.
Or he give you free. No way. There's nowhere. So you, whether you don't take 30 or 40 or 10 or 5 years, na 6 months, what's you na annual tenant? Now 6 months notice no more you're entitled to.
Okay, so when we look at this one, when a tenant at sufferance, how do they give a notice?
But tenant at sufferance, the law say you can enter anytime and evict the person. Don't forget, this person not pay rent for the period. He hold the property now. In term, the lease time we been get don't expire. So he did it now, he hold over the property. So you can, so that time where they leave the now at your own discretion when no pay rent. So now I make it, you see, it already used from a lawful tenant to a tenant at sufferance, or from a periodic tenant or a fixed term tenant to a tenant at sufferance. Say, in not the parent again, you get right for go and pull them anytime now that property day. And in fact, now that's when you go under the speedy ejectment because you know the parent. Some ejectment now for a tenant, we don't the parent, a lawful tenant. But anybody we don't on the tenant at sufferance, we don't hold over the property, you can even pull them by speedy ejectment for like common at the property.
So how you remove tenants at will?
Tenants at will, but now some ejectment. Because this not been person where you just put it, say, okay, this person is a day under this property under my permission, right? So if I want pull them, I dey give a notice. You not require for give them any period like we go say 6 months, 3 months, or 1 month, or 2 weeks. You can give them 3 days safe. You see, because na tenant at will, the person is residing on your property on your own permission. So you can write a notice and say, okay, you not tenant way I mean don't put today with me permission for the day and you are not paying rent because the tenant at will is not paying rent. It's a tenant will not the pay rent. So do ya in 7 days I will let you move from your house. It not require any statutory period of tenancy because it not the pay rent. So if you get under notice, they say 7 days reasonably if you move, it not move, then you can come under cap 49 for pull under the property. You should say the person, there has been a landlord-tenant relationship between you and the person, and you don't issue them with a notice, and the period stated in the notice don't expire and it not move. So you dey go now the court for make them give them the ejectment for make a move.
Somebody send this text message. He say, how to remove a caretaker from your premises? Do you need a court of action?
That's a good one. The caretaker is not a tenant, right? So the consideration where people can give no more that he's been working for you. Say, but this person, he don't do work for you. So most times he falls under the consideration of an employee, you know. Say, oh, he was doing some work for you, but he's not a tenant. I put and they say, take care of this my property. And when I am ready to take over my property, you should vacate. So now just that humanitarian consideration. I don't hear you then talk about say, oh, me caretaker, I don't need 20 years. In fact, some caretaker, they take further advantage of you, safe, then go get tenants now. The caretaker is not a tenant. You know, require anything like that. But now that human consideration, the law for evict person. So if he come, you know, I make you get the speedy ejectment. If in decide now, like say, if they can claim your property, then you can use speedy ejectment for removal. Because the speedy ejectment, they talk about somebody we were unlawfully lay claim to your property. Right? You don't go say, oh, now me get this property, or by reason of what you think, you say, I am entitled to this. It's not a tenant, so you can go for speedy ejectment.
Okay, so when we look at this removal, because some tendency people like you say the court slow, so then go on for do for themselves. So we then do them. Then people then they that one the way then landlord they wouldn't go for go pull then tenant by force. So then now crime they don't commit an offense or we think.
I know one say they don't commit an offense, but they have not acted within the law. And so you don't unlawfully evict, and that's how I go put them. You don't unlawfully evict somebody from the property. Okay, and that is not supported by law. That is why it is called unlawful eviction, because you know what you do not get the support of the law, right? So now I say when you want to forget the tenants, you don't need the law, but when you want to evict the tenants, you need the law for support you.
Okay, so they almost conclude now, and we want to look also if somebody don't pull. The court don't say it don't give the person 7 days, say come out na the place, or it don't get 1 month or 2 months, as the case may be. The person not come out. So waiting at the other remedy we available for get that person out of the property. Okay,
so now execution, because once the court don't give order, you get the power now of the court for make the court go execute, go enforce with the order. So the court don't give you 1 month. Say Bami Davis, you for left Mr. Mange Mansari in property 31st of May. 31st of May come and not come out. That order the way Mr. Mansari may don't get. Say for commodity 31st. They come na court. Can the bailiff or on the sheriff section, depending on which court he gets the order. If not the high court, be on the sheriff. If not the magistrate court, he can to the bailiff. The bailiff. Okay, whatever. Right. Okay, they get them. Then bailiff. Then they go execute that order. They for pull you now the property. Now they no more get the power because there is a court order for make you commodity. Sometimes You can get the situation then where if you no one do that themselves, you they come for contempt. You see, this person, there was a court order that if I don't move from the 31st of May, you know, move today, the 15th of June, you know, move. You they come for contempt because you're in contempt of a court order. And then they can get the law for let them go pull you by force. Or then bring you come to court on contempt, then go lock you in a cell for contempt, or you purge out your contempt. So there are processes.
Okay, thank you very, very much for you join me today in Court Ose, and I hope say we don't enjoy, we don't learn from waiting Mr. Claude Bami Davis, when a private legal practitioner. Don't talk about tenancy, waiting a tenancy, how you the pull person, how you the rent person, all of them things. Then they don't explain, and I feel say the one that we don't listen and the viewers themselves don't get knowledge of how they for treat the tenant or the landlord. Now, so we will do all the cutting down for the program, and plenty thank you to Theodore Arena. We help for produce the program. Plenty thank you to Fatu Bagba. We himself we are then to produce the program. Thank you to Mary. We make you see we live on Mary Kama Bangura. We make you see we live on Facebook. Thank you very, very much to DJ Caps, and we na the man with the we na the technical man, and me we present the program in name Namange Mansari. Until next week for another edition where we will get very interesting topic where Fambulen will benefit from. Next week, bye bye.